Hello and welcome. This is part 1 of the Memorandum in support of petition for writ of habeas corpus under 28 U.S.C. subsection 2241. And it was filed on February 18, 2025. And just so you guys are aware, the federal court already asked the prosecution to submit their response by February 26, 2025. Today's the 21st, so the prosecution in the Karen Reed case has just 5 days from today to submit their response to the federal court. And the federal hearing is scheduled for March 5th. So it's like they're expediting it, which is good news for Karen Reed. So I will begin reading this, and this will be a short video. As I'm reading this document, it's going to be a series. There will probably be 20 or 30 parts by the time I'm done. It's a lot, but thank you for being here. So again, it's the memorandum in support of petition for writ of habeas corpus under 28 U.S.C. subsection 2241. It reads, "Now comes the petitioner, Karen Reed, by and through undersigned counsel, and hereby respectfully submits this memorandum in support of her petition for writ of habeas corpus under 28 U.S.C. subsection 2241. Miss Reed is currently facing an April 1st, 2025 retrial in Norfolk County Superior Court after a prior mistrial in July of 2024. This petition contends that such retrial will violate Miss Reed's 5th and 14th Amendment protections against double jeopardy. The petition relies upon post-trial statements of 5 jurors, in parentheses 4 directly and 1 indirectly, that the jury in Miss Reed's first trial reached a final unanimous decision to acquit her of second-degree murder. Despite massive media publicity regarding these declarations, none of the other 7 jurors disputed the accuracy of these post-trial statements. In the usual course, the jury's verdict would have been announced in open court, and prosecution for that charge would be indisputably constitutionally prohibited. Here, however, the trial court, assuming but not verifying that juror notes indicating an impasse, referred to all rather than just several of the outstanding charges, failed to inquire pursuant to Massachusetts Rules of Criminal Procedure 27B regarding the existence of any partial verdicts, in parentheses, as well as failing to poll the jury, and for that reason the jury acquittals were not announced and a mistrial was declared without the defendant's consent." Pulling away from the memorandum, it's excellent so far. I fully agree. As if you've been following me long enough, you know that I argued Rule 27B before the defense even argued Rule 27B. And I had people commenting on my video about the language of Rule 27B like months ago, and how Rule 27B is written as a suggestion, and I've disagreed with everyone who ever said that. There's a reason for the rules of criminal procedure in the state of Massachusetts, and Rule 27B is a procedure. It is written in steps. The Judge Bev, was not supposed to declare that mistrial before she inquired as to the verdict of each count. That's how Rule 27B is structured for defendants with multiple counts. Karen Reed was and still is a defendant with multiple counts against her. And before Judge Bev was permitted to declare that mistrial, she was supposed to ask the jury if there were any verdicts on any of the counts. She was not supposed to take the jury notes at face value. I have argued this over and over again, guys. And when I heard Martin Weinberg months ago talking about Rule 27B, it was a hallelujah. It was like, yes, thank you, Jesus. It was like, someone please tell Judge Bev that she violated the rules of criminal procedure. Okay, I'm going to keep reading. Thank you guys again for being here. Continuing. Contrary to longstanding federal as well as state case law, the trial court gave no consideration to any of the existing viable alternatives to a mistrial, nor was defense counsel consulted or given any opportunity to be heard prior to and in relation to the court's declaration of a mistrial. At no time prior to the trial court's final sua sponte decision to respond to a jury note by declaring a mistrial had the trial court even mentioned the word, quote, mistrial, end quote. Excellent. Pulling away, for those of you who don't know, sua sponte means an order that a judge can write or declare themselves without a motion. So what they're saying is that Judge Bev sua sponte declared that mistrial. On her own, Judge Bev declared that mistrial without meeting the prerequisites, without giving the defense an opportunity to object, and without providing an alternative. Judge Bev swears up and down that the Tui Rodriguez instruction is an alternative to the mistrial, and it is not. The Tui Rodriguez instruction is not an alternative to a mistrial. It is merely a push to get the jury to come to a decision. There were multiple other opportunities Judge Bev could have taken as real alternatives to declaring that mistrial. And Rule 27B is actually an alternative to requesting a mistrial, but it's also the rules to declaring a mistrial before declaring a mistrial. Okay, continuing. In these circumstances, the Commonwealth did not satisfy its heavy, well-established burden of establishing manifest necessity as a condition precedent for the mistrial, which was declared in violation of petitioner's double jeopardy rights. The defense independently maintains that a jury's final unanimous agreement that Miss Reed is not guilty constitutes an acquittal for double jeopardy purposes, and that the trustworthy and uncontradicted post-trial affidavits entitled her, at minimum, to a judicial inquiry on this issue. The prosecution wants this court to, in essence, ignore the declarations of the jurors, ignore the possibility, if not probability, that the jury unconditionally, finally, and without any ambiguity, unanimously found Miss Reed innocent, and avoid any post-trial inquiry that could demonstrate that all 12 jurors unanimously rejected the sufficiency of the prosecution as to 2 of the 3 indictments. The defense has more than met, I think it's a typo, its burden of production regarding the jury's decision to acquit Miss Reed. Neither the trial court nor the SJC held otherwise. Instead, the state courts erected an impenetrable procedural barrier to prevent Miss Reed from proving what is clearly true that the jurors finally and unanimously agreed that Miss Reed did not commit the murder, in parentheses, not a second charge of leaving the scene, for which she stands charged. This ruling is irreconcilable with the constitutional interest in having decisions by jurors respected and honored. Public respect for the judiciary requires that agreements reached by a jury of the defendant's peers in a matter so consequential not be rendered irrelevant. For these reasons, federal courts favor post-trial voir dires, and the denial of such inquiry here violated Miss Reed's 5th, 6th, and 14th Amendment federal constitutional rights. This is excellently worded, by the way. Again, I am proud of Martin Weinberg. I'm proud of the defense team for taking this all the way to the federal court. Because we've had so many letdowns in the Karen Reed case, I'm not trying to get my hopes up. I don't want another bubble bursted, like, is the federal court gonna be the hero? Are they really gonna be the hero? I don't know. I really can't say. It can really go either way, guys. We've been let down by all the courts in Massachusetts, and this will be the district court in Massachusetts, which is supposed to have federal oversight, all its own, and I like to think that the federal government is different from the state government. But again, this is Massachusetts. It's like purgatory, It's like it's like a hell on earth. So yeah, it's been excruciating watching and observing this case unfold over the last year, especially. And yeah, I'm not trying to get my hopes up. I am praying that the federal court will do the right thing here. But it's like Karen Reed said, expect the worst. Yeah, like prepare for the worst, but hope for the best, essentially. Continuing, letter I, procedural background, or I believe it's a Roman numeral 1. Procedural background. On June 9, 2022, Miss Reed was charged in 3 separate indictments with second-degree murder in violation of Mass Gen Laws C-265 subsection 1, count 1, manslaughter while operating under the influence of alcohol, in violation of Mass Gen Laws C-265 subsection 13.5, count 2, and leaving the scene of a collision resulting in death, in violation of Mass Gen Laws C-90 subsection 24, 2A and a half, 2, count 3. And a jury trial began in Norfolk County Superior Court on April 16, 2024. The trial court declared a mistrial on July 1st, 2024. After the mistrial, Miss Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending 1, that the jury reached a final unanimous decision to acquit her on those charges, and 2, that there was no manifest necessity supporting the mistrial. As set forth in more detail infra, the motion was predicated in part upon affidavits by counsel reflecting statements of 4 deliberating jurors that the jury had agreed Miss Reed is not guilty of the relevant counts, in parentheses, and a second-hand statement attributed to a 5th juror stating that the jury had agreed Miss Reed is not guilty of murder. On August 22nd, 2024, after hearing oral argument, the Superior Court issued an order denying Miss Reed's motion to dismiss. I'm going to read this footnote back here on page 3. I'm trying to find what it pertained to. I think it's up here. Oh, right here. So in parentheses, it reads R139 to 44. And the footnote reads, the record appendix for Miss Reed's appeal to the Supreme Judicial Court is attached as Exhibit A to this memorandum. The citations to that record appendix correspond to the page numbers in the lower left-hand corner of each page. So it's just referencing the attachment. And in this last paragraph of page 3, if you guys didn't know, the word infra in the sentence as set forth in more detail, infra, the motion was predicated. Infra means in this document. It's just legal lingo, legal language in the document. Okay, continuing with the memorandum. On September 11, 2024, Ms. Reed filed a petition for relief to the Supreme Judicial Court, SJC, pursuant to Mass Gen Laws C-211, subsection 3. On September 19, 2024, a single justice of the SJC, Dewar J., reserved and reported the case without decision to the full court. On February 11, 2025, the SJC issued an opinion, hereinafter, quote, opinion, attached as Exhibit B to this memorandum. There's another footnote, number 2, affirming the denial of Ms. Reed's motion to dismiss. The SJC held that 1, the trial court acted within its discretion in deciding that the jury was at an impasse and that a mistrial was therefore supported by manifest necessity. I can't stand it. They're so wrong. The SJC is so wrong, guys. I'm pulling away from the memorandum. Again, if you guys haven't watched my video about the SJC decision, they're so wrong. All they did was copy and paste Judge Beverly Cannoni's prior decisions from her denial of the motion to dismiss. That is all the Supreme Court in Suffolk County in Massachusetts did. They did not behave as an appellate court. They did not behave like a Supreme Court. All they did was copy and paste Judge Beverly Cannoni's arguments. Oh, it's so angering. Continuing with the memorandum. Notwithstanding that the jury never clearly stated that the impasse extended to all counts, and the post-trial affidavits make that it did make it, in parentheses, and the post-trial affidavits make clear that it did not. Number 2, the trial court adequately considered alternatives to a mistrial, notwithstanding that the court's intention of declaring a mistrial was not so much as mentioned until the trial court sua sponte declared one. Exactly. Pulling away. So the SJC, you guys, listen carefully. The Supreme Judicial Court of Suffolk County in Massachusetts, they agreed with Judge Bev that Judge Bev sought alternatives before declaring a mistrial. When in fact, on the record, it is documented on the court record for all eternity. On the record, not once did Judge Bev seek an alternative. Not once. When Judge Bev says that the Tui Rodriguez was an alternative to the mistrial, she, as a judge in a superior court, is entirely and wholly incorrect. Okay, continuing. The trial court, number 3, the trial court was not required to consult with counsel or give counsel an opportunity to be heard regarding the prospect of a mistrial because it had previously solicited counsel's views on whether to give a Tui Rodriguez charge designed to prevent a mistrial in response to prior jury notes, albeit, in parentheses, albeit without mentioning the possibility of a mistrial. Number 4, the lack of a formal verdict announced in open court precluded any later claim that the jury in fact had unanimously and finally decided to acquit Miss Reed of 2 of the of the 3 charges against her. And number 5, the defense was not entitled to a post-verdict inquiry to substantiate its claim of acquittal because the availability of such inquiry is limited to claims of extraneous influence or juror bias. So the defense so far has provided the federal court the 5 reasons why the Supreme Court denied or reaffirmed the denial of Karen Reed's motion to dismiss. So, and it's so clear here that, again, like I said in the previous videos about the SJC decision, it is so clear here that the appellate court did not whatsoever conduct their own investigation of what happened in Judge Beverly Cannoni's court. They did not whatsoever review or conduct their own analysis of what happened in the Superior Court under Judge Bev's oversight. Again, all they did as an appellate court, all they did was copy and paste Judge Beverly Cannoni's arguments. And that is so inappropriate for an appellate court to do. They're not supposed to just copy and paste. They're not supposed to just regurgitate the lower courts. They're supposed to provide something of their own. They're supposed to be discerning in their decision. They're supposed to provide contrast, from what previously occurred. But it's just gray. It's just more corruption. It's just Judge Bev being corrupt and now the SJC being corrupt. They're so corrupt because they're not even behaving like an appellate court. What's the point of being an appellate court if you're not going to do things that an appellate court is supposed to do? Like all the taxpayers in Suffolk County, you should all be livid. I'm in Essex County in Massachusetts, but everyone in Suffolk County and in Norfolk County, you should all be livid that this is where your tax dollars are going, to a court system that doesn't actually work. Again, they care more about their paychecks than they do about doing the right thing. I'm going to read this footnote at the end of page 4. The parties' briefs filed with the SJC are attached as exhibits C, D, and E. Continuing with the memorandum. This is Roman numeral 2. Ms. Reed is entitled to federal review of her double jeopardy claim prior to retrial. Because Ms. Reed is currently released on bail, she is in the Commonwealth's custody as required to file a 28 U.S.C. subsection 2241 petition. See Allen v. Attorney something. It's an attachment. Sorry. They're citing an attachment. Continuing. The First Circuit has made clear that, quote, a petition for habeas relief that raises a colorable claim of former jeopardy need not invariably await trial and conviction in the state court. Such claims are distinctive because the Constitution insists that courts may not impose more than one punishment for the same offense, and prosecutors ordinarily may not attempt to secure that punishment in more than one trial, end quote. Excellent citation by the defense. Excellent. And what they're saying in the citation, what they're citing is a clause in the law that says Karen Reed doesn't have to wait to be retried because these are her constitutional rights. The jury found her not guilty of counts 1 and 3, and they were just stuck on count 2 because of Karen Reed's alcohol level, which again, I do not trust. I do not trust the alcohol level that the Commonwealth said Karen Reed had. If the Commonwealth lied about every other piece of evidence, if the Commonwealth if the Commonwealth failed to maintain a chain of custody for virtually every single piece of evidence, how the hell are we supposed to trust the so-called alcohol level they allege that Karen Read had? You know? So to me, count 2 is null and void. You know? There is no alcohol level. And to boot, guys, no one else was tested. Everyone else was drinking that night. Some people were even drinking and driving, you know, Brian Higgins, but nobody else's alcohol level was tested that night or that morning. Only Karen Read's. Isn't that some shit? Only Karen Read's alcohol level was tested. Continuing. They are citing a case, White versus United States. As the Supreme Court has observed, quote, the rights conferred on a criminal accused by the Double Jeopardy Clause would be significantly undermined if appellate review of Double Jeopardy claims were postponed until after conviction and sentence. To be sure, the Double Jeopardy Clause protects an individual against being twice convicted for the same crime, and that aspect of the right can be fully vindicated on an appeal following final judgment. However, this court has long recognized that the Double Jeopardy Clause protects an individual against more than being subjected to double punishments. It is a guarantee against being twice put to trial for the same offense, end quote. Abbey versus United States. Quote, obviously, these aspects of the guarantees protection. Okay, I'm going to read that again. Quote, obviously, these aspects of the guarantees protections would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken. I believe there is a typo there, guys, which is not uncommon. Okay, I'm going to read the last part again. Protections would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken, even if the accused is acquitted or if convicted, has her conviction ultimately reversed on double jeopardy grounds. She has still been forced to endure a trial that the Double Jeopardy Clause was designed to prohibit. Excellent citation from the defense. Continuing, another quote, to realize the solemn promise of this constitutional guarantee, federal habeas courts will be in appropriate circumstances entertain a claim that permitting a nascent, in parentheses, but as yet incomplete, state court prosecution to go forward would violate the Double Jeopardy Clause, end quote. Again, guys, I think there are a couple of typos. I'm going to keep reading. For reasons set forth in FRA, Section 5, the defense contends that Ms. Read's retrial on counts 1 and 3 would violate her federal constitutional protection against double jeopardy. Accordingly, Ms. Read, quote, may seek federal habeas corpus relief without first undergoing trial on the challenged indictments, end quote. And it provides a case law, Justices of Boss Munn. I'm not going to read the rest. Continuing, quote, because the Double Jeopardy Clause protects interests wholly unrelated to the propriety of any subsequent conviction, a requirement that a defendant run the entire gamut of state procedures, including retrial, prior to consideration of her claim in federal court would require her to sacrifice one of the protections of the Double Jeopardy Clause, end quote. Roman numeral 3, facts. We're on page, we're at the end of page 6, and I will read a little more and then make a part 2. On June 25, 2024, the jury in Miss Reed's first trial began deliberations after receiving instructions from the trial court. The court instructed the jurors, quote, "You should continue deliberating until you have reached a final verdict on each charge," end quote. June 25, 2024. It also noted that count 2 contained, quote, "lesser included charges," end quote, of involuntary manslaughter and motor vehicle homicide, which the jury should consider, quote, "even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor." Okay, continuing, end quote, and continuing the next paragraph, and then I will conclude this video. The following day, on June 26, 2024, outside the presence of the jury, counsel for Miss Reed raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Miss Reed not guilty, before going on to ask whether Miss Reed was guilty of the offense charged or guilty of one of the 2 lesser included offenses. See Exhibit B to affidavit in support of motion to amend jury verdict slip. Counsel asked that the form be amended to provide, quote, "not guilty" options for the subordinate charges under count 2. June 26, 2024, the trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions telling jurors that, quote, "count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that, quote, lead charge and, quote, if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order," end quote. And before I conclude it, I just want to comment that, yes, we all remember that the jury verdict slip appeared to defense attorney David Unetti, who had at the time of trial, at the time of deliberations, David Unetti was a standing defense attorney for the state of Massachusetts for decades. For decades. I'm not saying 4 as in the number. I'm saying 4, F-O-R, for decades. And David Unetti, in open court, said he's never seen a jury verdict slip like that before. Like, you know, there are supposed to be multiple safeguards in the court process, in the criminal court process, that protects defendants. You know, Rule 27B is one of those safeguards. And notice how Judge Bev did not use it. What safeguards there were for the Karen Reed case were safeguards that were going to be in favor of the prosecution and the court as a whole, as we have seen, as we have observed Judge Bev's bias throughout the trial, her bias, how she allowed the Commonwealth to get away with so much bullshit, how she didn't even blink an eye when she observed the lack of chain of custody for the evidence or the inverted video, you know, like, and she was so disciplinary when it came to the defense. But when it came to the Commonwealth, she was gracious. When it came to the prosecution, she was kind. You know, when it came to the jury members, she was kind. But when it came to the defense, Judge Bev was grumpy. She had a hissy fit nearly every day. She rushed the defense, you know? Like, she made that trial extremely difficult for the defense. She made the defense seem like they were an inconvenience to her, a burden to her, when their only job as a defense team is to defend and protect Karen Reed, you know? Like, as if it's Karen Reed's fault or as if it's the defense's fault that they're there in the first place, when this is the Commonwealth's case. This is the prosecution's case. It is because of the prosecution that Karen Reed had to be there unnecessarily, you know? But notice how Judge Bev treated the defense team as if this was all their fault, you know? So Judge Bev had safeguards, but the safeguards were not in place for Karen Reed. They were in place for the prosecution. And the way in which that jury slip was written was absolutely a safeguard for the prosecution. Had the defense team not spoken up and requested that the jury slip be revised, the jury members would have had to likely say guilty on count 2. And what would have happened to Karen Reed? You know, what would have happened to Karen Reed? The prosecution would have gotten what they wanted. And I said in past videos, count 2 was foolproof for the prosecution. It was written that way on purpose. 3 fucking instructions for 1 count, you know? And of course, they put the BAC level in there. They put the driving under the influence in there because they had a BAC level to correspond with it. And the jury members just could not ignore the BAC level, the alcohol level. You know? I argued this in past videos. Count 2 was written strategically so that if the defense said not guilty on count 2, they still had to decide on the lesser included charges. And one of those included charges was the BAC level. So again, guys, it was a safeguard for the prosecution so that the result would be in favor of the prosecution. You know? It's like Judge Bev protected the prosecution. She defended the prosecution when she, as the judge, is supposed to protect and defend the defendant. You know, when she knows that there is no chain of custody, when she knows that there are multiple conflicts of interest in this case, when she knows that there are multiple Brady violations committed, you know, Judge Bev is a witness to all of it. Even if she wants to pretend that she's not, even if she wants to ignore all those facts. I've never seen a case like this, ever. You know, I'm in agreement with Alan Jackson. I have never seen a case like this in my life. Safeguards so that the prosecution can get what it wants, but no safeguards for the defendant, who is innocent. I will make a part 2. Thank you for watching.